friends. I don't think I have to introduce Mr. Arvind Datar, Senior Advocate, Supreme Court of India, before the lawyer fraternity. There will be good lawyers, there will be good writers, there will be good academicians. But Sri Datar is 3 in 1. I don't want to list down the famous cases in which Mr. Datar appeared, or the books written by Mr. Datar. Everybody knows. So I don't want to rob his time. Time is limited. He has to reach the airport soon. So enjoy the lecture of Sri Datar. Enjoy his knowledge. Enjoy his words. Sir, floor is all yours.
I must thank the Kerala High Court Advocates Association for inviting me to give what is called the Learn from the Masters series. In law, I think one is never a master, one is constantly a student. But I'm glad that you're having this continuing legal education program. Amongst the chartered accountant, there is something called a CEP, and you must complete certain number of hours of continuing education. Maybe there is a good case for starting it for lawyers as well, because we have to constantly keep on updating ourselves. I was telling the president that almost, well, I think 30 years ago, there was a program designed by late Professor Madhav Menon, and there was a continuing education program on criminal law. And I remember it was off Madras, and we had Mr. Ram Jethmalani, we had Rajendra Singh from Jabalpur, we had my late senior N. Natarajan, all leading criminal lawyers had conducted this program. It was very popular. In the Madras Advocates Association, we used to have continuing education series on different subjects. I remember there was a series of lectures on evidence, on CRPC and so on, but somehow it did not continue. So I do hope that your association keeps up this lecture series on an ongoing basis. When I was asked to choose the topic, I said that one thing which occurs to me is that the law is shaped not merely by the majority rulings, but sometimes the law is shaped by the great dissenting judgments of our Constitution. What appears to be a dissenting view, what is a contrary view to the popular public opinion, later becomes the law of the land. And we have these dissenting views of Brandeis, of Holmes, etc., which became the law in the US. But I thought I will choose just 5 or 6 important dissents in the Indian Constitution, which later became the law of the land. Well, I was asked to say first a few words to the younger members of the bar. I'm so glad that all of you are standing here. I'll tell you how I got this initial taste for the Constitution. Soon after I joined the bar, within 2 or 3 days, I was to do a second appeal admission, and I was working in the library. And very senior lawyer from the Madras High Court, he saw me working and he said that I'll give you some advice. He says, you take the 15 years digest, 1950 to 1965. The younger members may not know, we used to have the 15 years digest, and thereafter used to have the 5-year digest, 65 to 70, 70 to 75, what's called the quinquennial digest. But he said you take the 15 years digest, and then you see the important Supreme Court judgments and study everything from 1960 to 1965. You will get a basic grounding in constitutional law. Apart from that, I also started reading, and I was telling the president that youngsters, I would recommend that you take the AIR Privy Council series. And I just took a Xerox copy. In the index, you will find some judgments are starred. They got a single star, double star, triple star. The star judgments are the more important judgments which have laid down important principles of law. So if you get time, go to the library whenever you're free, or borrow the AIR Privy Council volumes and start reading these star judgments. They did make a huge difference to me, and I hope you enjoy reading them as well. Not only the law, but you'll also get a flair for the way the arguments were marshaled and were dealt with by the Privy Council, by our Supreme Court, and so on. Now let me come straight away to the great dissents. The first, of course, is the A.K. Gopalan case, which was one of the first judgments in the Supreme Court. In fact, one quest of mine, I've just been following up with the librarian in the Supreme Court. If you take A.K. Gopalan's case, AIR 1950 Supreme Court, page 27, you will find that it is writ petition number 13 of 1950. Maybe it was an unlucky number, I don't know. But what is puzzling me is what is writ petition number 1? What is 1 to 12? So I'm just trying to find out. Once I find out, I'll write a small piece in one of the journals. But A.K. Gopalan was WP 13 of 1950. An interesting point to note is my colleague told me that he founded the India Coffee House, I believe. It became a very popular cooperative society. Now, in the A.K. Gopalan case, I don't know how many of you know that in the initial stages there were only 6 Supreme Court judges. And A.K. Gopalan had a bench of 6. The 7th judge, N. Chandrasekhar Iyer, came only in September 1950. So from January 50 till September, you had only 6 judges. Mercifully, no judgment is a tie in that period. Even A.K. Gopalan was approximately 4:2. B.K. Mukherjee dissented, partly dissented. But Fazal Ali, the first great dissent which I would recommend all of us, all the youngsters particularly should read, is the Fazal Ali's dissent. Now in A.K. Gopalan, what happened was there was a Preventive Detention Act of 1950 which detained a person, detained A.K. Gopalan and many members of the Communist Party. And the question was, if I am detained, I have rights under 19(1)D, freedom of movement. I have Article 21, I have Article 22. When you detain me, are you restricting my right of movement and is it violating 19(1)D? Does it amount to a reasonable restriction in 19(4) and so on? But the point I am making is, that was a time where after independence there was a communist movement, strikes were rampant, and the general feeling of the public was, yes, there should be a preventive detention law, these people should be detained without trial for a period of a certain point of time. The majority upheld the entire act except section 14. And section 14 of that act said that the court, the executive, need not disclose reasons to the court. That alone was struck down unanimously, but all the other provisions were upheld by the majority. And then comes the first masterly dissent of Justice Fazal Ali. Fazal Ali was a judge of the Supreme Court for just 2.5 years. And the way he has written this judgment is absolutely mesmerizing. He starts off by saying, what is the scope of 19, what's the scope of 21, what's the scope of 22? And for the first time, he says, do not consider these articles in isolation. You must consider them as an interplay between each other. There's no point saying that my fundamental freedom on 19 can be taken away under a law under 21 and I have got no opportunity under 19. And the way he discusses the the Japanese constitution, the US constitution, what is meant by due process, what's meant by procedure established by law, and it took great amount of courage for him to say that the entire act must be struck down. You can't detain a person without giving him reasons. You can't restrict his movement beyond a certain point of time. So Fazal Ali was the first great dissent. Incidentally, Justice Nariman has written a 2-volume set called Portraits of Dissent. It's really worth reading. He has, of course, discussed very, many more dissents, but I'm just confining myself to what I think were the landmark dissents. This A.K. Gopalan came in 1950. Now, I come to what is possibly the most beautifully written judgment, not only in India but perhaps anywhere in the Commonwealth. And I make such a bold statement because I have read this judgment over and over again, and it is the most beautiful piece of English literature, law, and the passion of the man comes out in that judgment. And I'm talking of the dissent of Vivian Bose in Anwar Ali's case. Now look at the facts, look at the boldness of the man, look at the genius of the man. Anwar Ali Sarkar was a case which came from West Bengal. It's actually state of West Bengal versus Anwar Ali Sarkar. It was first heard by a bench of 5 judges in Calcutta, Chief Justice Harris and 4 people, and the Calcutta High Court struck down this law. What was this law? There was a West Bengal special ordinance which had a fast-track trial procedure where the accused did not get enough safeguards which were otherwise available to them in the Code of Criminal Procedure. Now look at the offence. 50 armed dacoits, members of an armed gang, raided the Jessop factory in Dum Dum in Calcutta. They were tried and convicted by this special law. The question was, this West Bengal special ordinance of 1950 was challenged on the ground that how do you pick and choose? Why should one person go for the fast track procedure, other person go, same person, same armed dacoity. What basis you choose Mr. Datar as for the special track procedure and Mr. X for the non-special procedure? That was the main question. By that time, this judgment was delivered on January 11, 1952. By that time, you had 7 judges. 6 unanimously overruled the West Bengal judgment. They said no, such an ordinance is fine. They said these are difficult times. These people, 50 people have raided the factory, etc., etc. So they went by the facts of the case and they ultimately upheld the law, said such a law is maybe necessary in these times. And now comes the dissent of Vivian Bose, which I think should be read every year. Like we do take the Law Day pledge, I think it is worth reading it once a year at least. And I'm not exaggerating, you just read that judgment and you'll know what I'm talking about. This is a judgment where Justice Vivian Bose analyzes what is the scope of Article 14. When you say equal protection of the law, equality before the law, what is equality? What is equal protection? What do you mean by law? And then he goes step by step and says, we are dealing with a constitution. And he uses a wonderful expression. He says, our constitution is not a mummified manuscript. He's saying it's not a mummified manuscript. It is not a fossilized document. It's a living document. And he said we should ask ourselves the question, can this kind of law, where without any logic or reason, a group of people are put in the special act, without any distinguishing feature, can you support such a law? Does the social conscience of a sovereign democratic republic support such a law or not? And then he says, on what basis does Mr. John go to the special act? Well, Mr. Rahim doesn't go to the special act. And then he goes on. And then finally, he, after discussing what's the importance of democracy, what's the importance of freedoms, what's the importance of occasion, he says, don't let bad facts color your mind. Think of the longer vision or longer term. And then finally, is one of the most beautiful passages. He says, how does he strike down the law? He puts it very nicely. He says, when the froth and foam of discussion is cleared away and the learned dialectics are put on one side, we at last come to the human element, which to my mind is the most important of all. The way it says, when the froth and foam of discussion is gone, dialectics are put aside, finally go to the most important thing. What is the Constitution for? It's for that human element in every citizen. And then he goes and says, I will strike down the whole law. It's an absolute masterpiece of this. Incidentally, Vivian Bose also had a wonderful dissent in Ram Singh, where he used the word cribbed, cabined and confined, which Justice Bhagwati then used in Roy Power. But the original word is by Justice Vivian Bose. So after the second dissent, this was the first time where he expounded the scope of Article 14, and this analysis of 14 was then relied upon directly or indirectly in subsequent judgments in defining what is the meaning of equality. It's not just height-bound equality. He says equality is not just mere classification like what Aristotle thought it to be. All the time you keep the human element, what is the role of the citizen, what is the impact on the citizen, always keep that in mind. That's the second dissent. The third interesting dissent is in 1960. Now I'm coming to two dissents by another extraordinarily great judge, Justice Subbarao. You know, I did not know that till 1960, the language of Article 226, if you had a writ petition against the union government, you had to file it first in the Punjab High Court. You could not go anywhere else because Delhi was the seat of the government. And before the Delhi High Court came, Punjab had jurisdiction over Delhi. So you had to go to the Punjab court. There is a very interesting case called Lieutenant Colonel Khajur Singh, where Subbarao dissented, and he said that why should Article 226 not be filed in independent states, in different states? What is important about these dissents from the academic point of view and for young lawyers and even older lawyers like us is, what fascinates me is the analysis done by the judge in arriving at a conclusion. But here is the question. In CPC we say, where is the suit to be filed? Where the defendant resides. You got section 16 to 20 CPC which says where the defendant resides. That's the normal place where the suit is filed. But Subbarao, Justice Subbarao, says that the central government is everywhere. And how does he say that the Kerala High Court can challenge the decision of the Union of India? He says, and that's a very interesting analysis, he says that please see Order 27, Rule 3 of the CPC and Section 79. When you file a suit against the central government, there is no need to mention the address because central government has no address. It is all over India. And he refers to a full bench judgment, Maqbul Nisa versus Union of India of the Allahabad full bench. And he says that when you deal with a writ petition, you are not concerned with where that government officer is sitting. You are concerned with which state in his action has affected the citizen. So if an action is taken in Delhi and it affects a citizen in Kerala or in Tamil Nadu, then that High Court has the jurisdiction. And it was this judgment which eventually led to the 15th Amendment, and in 1963, even if part of the cause of action arises here, the writ petition can do it. But please take the trouble of seeing Khajur Singh, and I love the way in which he relies on CPC, extrapolates to 226, and then he says what is India, what is territory of India, what is cause of action, what is part of cause of action, and so on. And that's how he develops the law and says that central government is everywhere and you can file a suit wherever the action of the central government impacts a citizen. That High Court has got the jurisdiction to take action against the central government. All High Courts have got the same action. But again, he was a dissenting. But again, once again, his dissenting view led to a constitutional amendment. And today we have got writ jurisdiction where High Court judges in Kerala can issue a notice to an office in Delhi as well. That's the next part of Khajur Singh. Now I come to fourth dissent, Khadak Singh, which is a very, very emotional case. And another masterpiece of Subbarao. Was again a judgment of 6 judges. Subbarao, and in fact Khadak Singh was there, and another judgment of 8 judges. That's why Puttaswamy went to 9 judges. We had the occasion of arguing part of the judgment, of privacy judgment, which was 9 judges, because the Attorney General in the Aadhaar case suddenly said that privacy is not part of fundamental rights at all. And there were 2 judgments, one of 6 judges and one of 8 judges, which said that our constitution doesn't recognize privacy as part of part 3. And then we relied on a large portion of Justice K.K. Matthews' judgment where he talks of the penumbra of constitutional rights and so on. But today what my point is, once again look at the facts. These are the great judges who did not let the temporary facts cloud the larger constitutional vision. Khadak Singh was a history sheeter. He had a track record of criminal activities. And on the UP state surveillance rules, whenever he had to go out of his village, he had to report to the police station. When he came back, he had to tell them, I have come back. Because he was a history sheeter, that rule enabled the police to knock at his door at any time of the day or night. And in the affidavit, he says, yes, repeatedly they have come at 1 o'clock in the morning, 2 o'clock in the morning, woken me up, taken me to the police station, asked me some questions, asked me to go and so on. And if you see the dissenting judgment of Subbarao, he says that this man has a bad record. But I will not decide this constitution on the basis of one man's bad record. I am thinking about the citizens of India. And then he goes into what's the meaning of liberty, what's the meaning of personal liberty, discusses the US Constitution, Canadian Constitution, and then he comes and says that if this is the surveillance, where a man, and he says, he uses the famous English phrase that every man's home is his castle. He says, if I'm not safe in my home, if anybody can knock on the door at any point of the time, then the whole country is a jail. It's a masterpiece of visualization where he says, nobody is safe in this country if these surveillance rules are there. And he struck it down. He struck it down in 1962, and in almost after 50 years, 60 years, his minority view then became the majority view. But the importance of Khadak Singh is twofold. That seeing personal liberty not through the lens of individual cases, but what will be the impact of this view on larger number of people. Khadak Singh may be a bad man, but look at the potential of misuse. What is the safety of a citizen if anybody can come to your house at any point of time, ask you to report and do all these things? So that is the great thing of Khadak Singh. Khadak Singh is 1962. Now, I came to A.K. Gopalan, then I went to Anwar Ali Sarkar, I went to Khajur Singh, I went to Khadak Singh, and now I come to one judgment which is very seldom noticed, but to my mind is one of the turning points of our constitution. Now, those of you who know, who study constitutional law, will find that immediately after our constitution came into force, the zamindari laws were struck down by the Patna High Court, Bombay High Court, Madras High Court, etc. You must have heard of Kameshwar Rao's case. And immediately the First Amendment was passed. Right? And please note, the First Amendment was passed by the same assembly which continued. We didn't have a new parliament in then. So one question which is raised is, it was a unicameral legislation. You didn't have lower house and upper house. One question raised is, was the First Amendment valid? Because where is the approval of the Rajya Sabha? Could such an amendment be passed? But that amendment was upheld in Shankari Prasad's case, saying that these land reform laws are correct, and we had a unique situation where we had a 9th schedule in the constitution which said that once you put the law in the 9th schedule, you can't challenge it on the ground it violates certain fundamental rights. In fact, I'll tell you a story. If you read Granville Austin's book, Working a Democratic Constitution, who got this idea of 9th schedule? There was a law secretary called P.M. Sundaram. The government of India was worried that court after court is striking down this compensation legislation, acquiring zamindari law. What to do? We had a brilliant lawyer in Chennai who was not very articulate, but an outstanding original thinker, V.K. Tirvingadachari, was our Advocate General. So he told Sundaram, why don't we create a non-9th schedule and then say that once the agrarian reform law is put in the 9th schedule, it will be protected from constitutional challenge. So some scholars sarcastically remarked that this is the only constitution which has a schedule to protect the constitution from other constitutional provisions. So that was the joke about the 9th schedule. But anyway, the 9th schedule came. Shankari Prasad upheld the 9th schedule. And those of you who are interested, there is a lovely book called 16 Stormy Days by Tripur Daman Singh. And the full book is about how the First Amendment was prepared, drafted and so on, what happened, what was Nehru's reaction, all these reactions are very nicely captured in this book called 16 Stormy Days. It's on Kindle. Now, Shankari Prasad came in 1951. Then you had a series of amendments. In fact, as a student of constitutional law, I feel that half the litigation could have been simply avoided if the government had been slightly more reasonable in paying compensation. You had first compensation, then it became amount, then it became non-justiciable. So you had First Amendment, then you had Bela Banerjee, then led to the Fourth Amendment, you had Vajravelu Mudliar, one more amendment. So these are all amendments after amendments where the tussle was between agrarian reform, zamindari abolition and payment of compensation. And just to digress a minute, I'll tell you one interesting story. When I wrote Courtroom Genius with Mr. Suri Surabji, we studied all the important cases argued by Mr. Palkewala. You have the bank nationalization case. Right? On a Saturday, an announcement is made nationalizing 14 banks. Now, I was wondering why 14 banks? Why not 16? Why not 12? What is this 14? You'll be surprised to note that the 14 banks were chosen because these 14 banks had deposits worth more than 50 crores. That's the value of money. Today, individuals have deposits more than 50 crores, but those days, these 14 top banks had deposits of more than 50 crores. I'm not exaggerating, see that. Then the bank nationally was challenged by Mr. Palkhiwala. Rustam Kawasji Cooper, who was the director of Central Bank, they prepared the writ in less than 24 hours, filed it. It came before the bench, and as you know, the bench of 11 judges ultimately held the law bad. But I want to tell you one thing. When the bank nationalization judgment came, a lot of people, particularly on the left, they said it's a anti-people legislation. These are all people who are meant for the bourgeois and so on and so forth. Huge criticism came. But once again, I find very often people criticize without reading the judgment. You have a right to speak, but there is no duty to think before you speak. If you read the bank nationalization case, Palkhiwala lost on almost every point. Where did he succeed? He succeeded because this inadequacy of compensation. If you read the last 13 paragraphs of the judgment, you will find that banks were to be nationalized. And when you nationalize the bank, take over the assets, you have to pay compensation. How was the compensation to be made? What they said was, they will not give you the market value of the building. Suppose this is your bank and this is your building. They will not give the market value. They won't even give you 70% of market value. They will take under rent control laws, what is the fair rent of that building. So in Maharashtra, see, like my apartment in Bombay, we paying rent of 80 rupees, but the market value will be of 75 lakhs because rent control, you can't increase the rent. So they took the market value of the flat as per rental value, multiplied it by 12 or 18, that's your compensation. But the icing on the cake was this compensation will be converted into bonds and paid after 10 years. So ultimately you got nothing, and that was the portion which was struck down. And what did the government do? They redrafted the bank nationalization, and ultimately they paid 84 crores more to 14 banks. If they had paid this extra amount in the beginning, all this problem would have been sorted out. So the point I'm making is, coming back to Shankari Prasad and the first schedule, a lot of the litigation was because of these lack of compensation. Now, 1950, 1960, 65. By 1965, we had the 17th amendment to the Constitution. And every major amendment, they'll put the law in the 9th schedule. So you can't challenge it. This was the case of Sajjan Singh versus State of Rajasthan, AR 65 Supreme Court. Now there's a history to this, and I've written it in the courtroom genius also. This was a case where a large number of coal mines, sugar mills were also affected because their properties were taken away and payment of compensation was very, very minimal. Mr. Palkhiwala was to appear in that case, and they told him that please come today because the matter may get over at lunchtime. He said, no, I don't think they'll conclude. I'll come tonight and I'll argue tomorrow. As bad luck would have it, Gajendra Gadkar refused to adjourn the case. The arguments were closed, judgment reserved. He could never argue the case. And why I mentioned this was, Mr. D.M. Popat, who was the partner of Bulla and Bulla, when he had a long conference with Palkhiwala on this Sajjan Singh case preparing, they asked the question, see if you can amend the constitution. Till where can you go? Can you take away all the fundamental rights? Can you take away 80% of the fundamental rights? Where do you draw the line? So Palkhiwala asked in the conference to Popat, in the process of amendment, can you abrogate the constitution? There's all discussion, but that was never put forth to the court. But look at what happened actually. 5 judges heard Sajjan Singh's case. I would request you, apart from the majority of Gajendra Gadkar, he says now all these issues are covered in 1951. What is the issue covered? Parliament's power under Article 368 is untrammeled. They can amend any part of the Constitution. From Shankari Prasad till Sajjan Singh, any part of the Constitution could be amended. There was nothing, no unamendable part. 2 judges whose judgment I would request you to read is Hidayatullah and Mudholkar. And why I say this judgment has not received attention according to me which it deserves. Actually they are not dissenting because both Hidayatullah and Mudholkar say, yes, we agree with my Lord the Chief Justice that 17th Amendment is valid. Then the beautiful passages start. First, Hidayatullah says, I am feeling a sense of unease. He says, the very funny part of our constitution is, he says now 17 amendments have taken place. Right after right is gone, everything is put in the 9th schedule. He says, if you go to Article 368, if you want to amend fundamental rights, simple procedure, no ratification by the states, this 2/3 majority, simple procedure. But if you want to amend certain subsidiary provisions, then you have an elaborate procedure, so many safeguards. So he says, I find it difficult to believe that I can take away a man's freedom of speech, but something relating to some state election, I have to take ratification by states and so on and so forth. And he says, look at the paradox. To amend Article 226, I have the elaborate procedure, but to take away Article 32, simple procedure. This is what the founding fathers had. And Hidayatullah uses a very nice expression. He says, I am worried whether fundamental rights are the playthings of the majority. Use the word playthings of the majority. And he says, I'm just expressing my reservations. Now comes to a masterly dissent by Mudholkar, which I would rate in the league of Vivin Bose, Subbarao and Mudholkar. Mudholkar starts off by saying, I agree that amendment is valid. But then they realize that in 15 years you amended the constitution 17 times. Where do you draw the line? He also says that look at fundamental rights. He says, he asks a very interesting question. He says, if you take away the right to speech, if you take away the right to liberty, theoretically, are you amending the constitution or rewriting the constitution? If your constitution doesn't have the right to life and liberty, if it doesn't have the right to free speech, is it the same constitution? And then he says, this is a freedom struggle, we won all this and that. And for the first time, he uses the word, the first time anywhere in the Indian constitution, find the word basic features is in Mudholkar's dissent, not by Dieter Conrad as we keep on hearing. It is in Mudholkar's judgment, his basic features, he says. Can we take away what can be called the basic features of our constitution? And where are these basic features? Mudholkar puts it beautifully, he says, our preamble is sublime. And our basic features of our sovereign democratic republic are contained in the preamble. Liberty, equality, fraternity, justice. These are all parts of basic features. And he says your preamble is your basic feature. These are all the values enshrined in the preamble which are reflected in part 3. And he says, can we take it away easily? The second interesting part of Mudholkar's judgment is, ironically, he then refers to a judgment of the Pakistan Supreme Court, where they use the word essential features. They don't use the word basic features. At that time, Pakistan Chief Justice was a Christian gentleman called Chief Justice Cornelius. They struck down certain laws of Pakistan saying that they are violating essential features. So the beauty of Mudholkar's dissent is, he says that the basic features are in the preamble and it's a part of fertilization, cross-fertilization of laws, that he takes the Pakistan Supreme Court as a persuasive precedent and then says that these are the basic features. But he concludes by saying, I am just flagging these concerns for another time, but there is a sometime or the other, the time will come to examine that, and that exactly happened after 2 years when Golaknath, of course, it went to the other extreme, and then it came to Kesan Bharati. So you'll find that Mudholkar's dissent first sowed the seeds of basic features, and it's a tragedy that that judgment is not noticed and not read as much as it should be. Just Mudholkar's dissent, I would request all of you to read. Now, because time is short, I'll just come to the last dissent, which all of you know, and I won't waste too much on time, which I think you should read, is the dissent of H.R. Khanna and A.D.M. Jabalpur. See, we all talk of dissent, we always remember H.R. Khanna, how he wrote the dissent, and then he lost the Chief Justice post, and then he wrote the book, Neither Bed Nor Roses, Neither Thorns Nor Roses, his book and so on. But, having said that, the true flavor of what H.R. Khanna was driving at must be read after you read the majority judgments also. see the judgment of Beg, of Chandrachud, and so on, and then you come to H.R. Khanna's dissent. See, in H.R. Khanna's case, the law was completely against. In the emergency, all the rights were suspended. All the rights were suspended. But H.R. Khanna, starting from the Magna Carta, makes a masterly dissent and says that liberty is something you can't take away. You can't suspend liberty. The rule of law, beyond a point, a human being's life can't be simply, you can't say, because the question put to Nirande was, suppose you shoot a man, does he have a remedy? He says, no, your fundamental rights are suspended. That was the argument made, that you have no fundamental rights at all. You can't approach under Article 226, you can't approach. In fact, people who approached the courts under 226 did not go under Article 21. They went because some provisions of NISA were not satisfied, and then the detention would be challenged. But no fundamental right could be taken. But H.R. Khanna's dissent, the last 34 paragraphs are beautiful and worth reading. I didn't expatiate on that because most of us know of it. My aim here was to highlight to you other important dissents which we have lost track of. So friends, these are the important dissents I meant. After ADM Jabalpur, there is no great landmark dissent that I have seen anywhere. Of course, you have some other views here and there, but a dissent which was appeared to be completely revolutionary in that sense at that period of time, which then became the norm later. These are the really 5 or 6 cases which I wanted to highlight. Thank you so much for giving me a patient hearing, and I would request all of you, when you go back, at least in the next 2 days or before the Onam holidays, please read Vivian Bose, read Khadak Singh, read Mudholkar, and read H.R. Khanna. Thank you so much.
Now to the most awaited part of the session, interactive session. If any of you have any doubts to ask the learned senior, may kindly.
Can you please tell your names?
C. Rajendran. Can we have a scrutiny by the Honorable Apex Courts before putting an enactment in the ninth session?
Because that's it is done by Parliament. Parliament decides when they amends the Constitution to put these. In fact, putting the laws into the 9th schedule is by the Constitution amendment itself. Only thing is, now after that 9th schedule, where after 24th April you can challenge the name of the person. I from Mysore. What's that? Ayar Koilo. Koilo now says that the 9th schedule is no longer. You can, beyond 24th April 1973, any amendment made thereafter can be challenged on the grounds of basic structure. And we did succeed in NJSC on basic structure. In fact, only 5 judgments have succeeded challenging basic structure after that. But to answer your question, there can be no scrutiny by Supreme Court. Scrutiny will come after it's put in the 9th schedule. And mind you, when you come to a basic structure challenge, we have done it twice. It's a very, very difficult challenge. Your challenge is on a very small sliver. What is basic structure? That itself is a nebulous concept. So if you read the judgment in the judge's case, appointment case, NJSC case, we relied on the essential part of independence of judiciary as part of the basic structure. Then you take the other case of Sambamurthy, where they said under Article 371D, the judgment of a court can be reviewed by the executive. They struck it down as violative of basic structure. So the challenge is very limited.
Can we repeal the whole constitution at present and make another?
No, now you cannot. After 24th April, you can't. 1973.
In Shankari Prasad, the presidential order to remove difficulty, that is, how do you comment?
Shankari Prasad. No, it was. I think, very frankly, in my opinion, that I don't agree with the views of Honorable Justice Patanjali Shastri. But that is now 51. That became the law. It was followed till.
No, I wanted to know how do you feel? Was it really correct on a legal point of view?
No, according to me, with 368, they could not have done it by unicameral. They could not have done it.
And provincial assemblies, in the absence of provincial assemblies.
Correct. They could not.
Presidential order, only in the event of removed difficulty.
Yes. But then Supreme Court is final because it is infallible because it is final. No, actually, if you see at that point, because there were so many zamindari legislation struck down left and right. I mean, it was completely derailing and Pandit Nehru's speech was very, very strong. He says, I mean, he criticizes the judges. I mean, you're not understanding the very basis of our freedom movement to abolish zamindaris and abolish to be.
On a different angle.
Correct. I don't know.
The friendly relationship to foreign countries. Is it a ground for amending Article 19? We are talking about the American Constitution, First Amendment. Here the First Amendment is totally against it. Friendly relationship to foreign countries. Is it a ground for to make law? Curtailing enabling the state to make law?
See, there I would slightly differ from you because the First Amendment is extreme and it has led to its own challenges, the First Amendment on the free speech. It's led to an extreme. So you virtually can't question it. For us, after 19.1a, you got 19.2 which came in the ECC. Now suppose you got a free press. Suppose there is a very sensitive relation with a neighborly country or some other country and you allow the media to make, so they can make a reasonable restriction that don't say something which is against friendly.
Based on the speech of one individual leader, that amendment was necessitated on the basis of his speech, the speaking attack against etc.
But anyway, that is the law now. You can, it's maybe a ground to justify it, you see, because again, we should also realize that in that time, what kind of a democracy? We had just come out of independence, we had a horrors of partition, there were so many sensitive issues.
Possibly one dissent that you have not looked at is M.M. Punchu's dissent in Judge's case. That is what is troubling us right now on the independence of judiciary. M.M. Punchu's dissent in the Judge's case.
Actually, I did not go into so many dissents because my focus was on dissents which ultimately became part of the majority view. So I was focusing on that and I was focusing on judgments which are of extraordinary beauty and quality. I'm not saying anything against this Punchi, but that's not part of the judge's case, first case, second case, third case. So for example, there are again dissenting. For example, you take in Bennett Coleman, very strong dissent by Justice Matthew. He says right to free speech doesn't mean right to keep writing all sorts of rubbish like. It doesn't use of rubbish, but he says that right to free speech doesn't mean the right to speak whatever you want. So Justice Matthew upheld the newsprint control order. A. and Ray struck it down. That's again a powerful dissent by Justice Matthew. So, but then that did not become a majority view later. So I have other dissents are also there which I did not get into.
Yeah, but this changed the very nature of our judicial system and the setup. And probably we have a judiciary that is not anymore accountable. And that is exactly why I was speaking about that aspect.
Well, I must tell you, I've been hearing this, where judges choose judges not accountable. Kindly read the detailed judgment of Keher and Lokur. When we argued this case, I had a wonderful bunch of interns. There are 193 nations in the United Nations, 193 countries in the United Nations. We prepared a detailed report of the appointment process in each and every country. Right from an absolute kingdom where the king appoints, to a process where parliaments elect judges. In New Zealand, the Attorney General recommends the name. So there are various processes. But to say that they are not accountable is not correct, because even the process of selection of judges, if you see, the affidavit filed by Mr. Mukul Rohtgi was till 64-65, whatever was recommended went through. It's only after the friction started between the judiciary and the executive, which culminated with judges transfer, supersession, the problems became. So to say that, judges are imperium and imperio, etc., to my mind is not correct at all. There are so many checks and balances. The local chief minister has to give his comments. The Supreme Court collegium, it has to go to the ministry. They have to give the comments. To say that we can appoint whomever like, not correct. Then we would not have so many vacancies at all. Names are gone and they are not come approved for so many months. So that's my view. Sorry. I wouldn't say that the collegium is not accountable. It is subject to so many checks and balances in its own way, which are highlighted by Justice Lokur and Justice Keher in that 5-judge bench.
Now I'd like to invite our President, Sri Rajesh Vijayan, to give a token of appreciation to learned senior advocate Arvind Datar sir. I would like to extend my deepest gratitude to learned senior advocate Arvind Datar sir for consenting for such a session, and also for interacting with the lawyers here at the bar, especially in between his tight schedule. And in fact, sir, we as young members at the bar were really thrilled to know that you were here for a session, especially on such a topic. Thank you, sir. Thank you for being here. Now I would like to extend our deepest gratitude to Sri Justice P. Govindan, sir, for being here and supporting us in all our endeavors. Thank you, sir. And I would like to express my gratitude to all the senior advocates and all my dear friends here, and thank you very much.